Welcome back, everybody. I hope you had a good break. We're about to hear from Katie DiTommaso and Suk Dial with some updates on recent auto coverage case law. That will include the always fun leased car, multiple insurer scenario, and the courts, another case on the court's ongoing struggle with what use, ownership, and operation of an automobile really means. So without any further ado, I'll pass it on to Katie.
Thank you, Frank, for that kind introduction. Good morning, everyone. It's a pleasure to be presenting to you with my colleague, Suk Dial. Suk and I had the privilege of presenting together at the inaugural Stieber Burlack Annual Insurance Seminar back in 2015. And it's our pleasure to be before you again in 2020 for our first ever client webinar. Thank you for taking the time to join us today. Before delving into the content of our presentation, we would like to acknowledge the hard work of our colleague Michael Connolly for doing much of the heavy lifting for our paper, which you will find in the materials. We are indebted to Michael for his excellent and valuable contributions and wanted to acknowledge him at the outset. All right, let's get started, shall we? Suk and I are here today to provide you with an update in the area of insurance coverage cases, particularly those cases dealing with the area of auto coverage. As many of you know, we here at Stieber Burlack have a very strong team who litigate these cases for you and your policyholders on a regular basis. Today, we're going to highlight some recent Ontario Court of Appeal decisions in the area of auto coverage, which includes an Ontario Court of Appeal victory of our very own Carolyn Gronke. For those that handle and litigate auto cases, you know that coverage issues can arise in multiple ways: leased vehicles, uninsured drivers, instances of overlapping coverage where there are multiple insurance policies in place, and facts that give rise to an argument over which policy ought to respond. Today, we're going to discuss the recent Court of Appeal decisions in all of these areas. We hope to provide you with some clarity as to where we are in the law currently and forecast where the court will go in deciding future similar cases in order to help you manage these types of cases should they arrive on your desk. The first case I want to discuss is the Ontario Court of Appeal's decision in Aviva Insurance and Wawanesa Mutual Insurance Company. This is an auto coverage case dealing with leased vehicles. When someone is involved in a motor vehicle accident in a leased vehicle, there is a section of the Insurance Act, Section 277, subsection 1.1, which kicks in. And this section sets out the rules which apply to determine the order in which the third-party liability provisions of any available motor vehicle liability policy shall respond. In respect of liability arising from or occurring in connection with the ownership, or directly or indirectly, the use or operation of the automobile. The priority is, first, any policy under which the lessee of the automobile is entitled to indemnity. Second, any policy which the driver of the automobile is entitled to indemnity. And third, any policy under which the owner of the automobile is entitled to indemnity. The purpose of Section 277 is to allocate risk and relieve the insurer of the owner of the rented vehicle from being the first loss insurer where other insurance is available to the renter or the driver of the rented vehicle. And that was set out by the Court of Appeal in 2010. It results in a cascading priority effect in relation to the insurance claims arising in the rental vehicle context. Insurance available to drivers operates in excess to insurance available to lessees. And insurance available to owners operates in excess to insurance available to lessees and drivers. To determine who is the first loss insurer under Section 277, it is first necessary to determine the identity of the lessee and whether that lessee is entitled to indemnity under a motor vehicle liability policy. Keeping that in mind, let's jump into the facts of our first case. Mr. Mahamood was driving a rental truck and he rear-ended a plaintiff. The truck was owned by the rental company New Horizons. At the time of the accident, Mr. Mahamood, the driver, was delivering some furniture for his employer, Fine Furnishings. The plaintiff sued Mr. Mahamood, the driver, his employer, Fine Furnishings, and the owner of the rental truck, New Horizons. Aviva was the insurer for New Horizons, and Wawanesa was the insurer for Fine Furnishings. The two insurers could not agree on who was obligated to respond to the loss. Aviva, insurer for New Horizons, took the position that the lessee was Fine Furnishings, and Wawanesa, insurer for Fine Furnishings, took the position that the lessee was Mr. Mahamood. Aviva brought an application seeking a declaration that first, Fine Furnishings was the lessee of the rental truck operated by Mr. Mahamood, and second, at the time of the collision, Mr. Mahamood was acting as an employee of Fine Furnishings as opposed to an independent contractor. The judge hearing the application found that Fine Furnishings was not the lessee of the rental vehicle, but rather Mr. Mahamood was the lessee. The application judge left the determination of whether Mr. Mahamood was an employee versus an independent contractor to the trial judge. Mr. Mahamood did not have any motor vehicle liability policy of his own, and so the application judge made an order declaring Aviva as the first loss insurer because it insured the owner. The application judge went through the previous list, number 1 to 3, that we had just discussed, applied the facts, and landed on number 3. Aviva disagreed and appealed to the Ontario Court of Appeal. Aviva argued the application judge should have taken into account all of the relevant circumstances when determining the identity of the lessee. Aviva advocated for a more nuanced evaluation of the circumstances under which the lease occurred. In other words, do not just simply look at the lease and the name of the individual or entity on the lease agreement. There are circumstances when the court can go beyond the contract to examine what role the lessee had in leasing the vehicle. In this case, was the lessee something other than just an individual leasing a truck? Was he an employee? Was he acting in the course of his employment duties? Was he an agent of Fine Furnishings? All of these questions can and must be asked when determining who exactly is the lessee in the circumstances. And the Ontario Court of Appeal agreed with Aviva. The Ontario Court of Appeal engaged in more than just a superficial glance at the facts. Rather, it went beyond the veneer to examine all relevant circumstances into account when determining the identity of the lessee. Starting with the driver, Mr. Mahamood. Mr. Mahamood did not have his own insurance, his own motor vehicle, or even his own credit card. When he was working for Fine Furnishings, Mr. Mahamood would always obtain his rental vehicles from New Horizons because Fine Furnishings had a standing arrangement with New Horizons under which Fine Furnishings authorized New Horizons to charge the cost of rental vehicles directly to a credit card on file. On the date of the loss, Mr. Mahamood rented the truck from New Horizons only for the purpose of delivering Fine Furnishings furniture to its customers and was in the course of doing so at the time of the collision. In terms of the evidence regarding Fine Furnishings, the owner gave Mr. Mahamood the authority to rent the truck from New Horizons to deliver furniture and charge the rental to Fine Furnishings credit card. Use of the vehicle was limited to delivering furniture, and Fine Furnishings paid for gas. When Mr. Mahamood presented himself at New Horizons to retrieve the truck, he said he was picking it up on behalf of Fine Furnishings. And in terms of the evidence regarding New Horizons, it admitted that when it was contracting for the truck rental, it understood that it was contracting with Fine Furnishings and not Mr. Mahamood, even though his name was on the lease. In determining the identity of the lessee, the Ontario Court of Appeal veered away from the application judge's strict contractual interpretation of the rental agreement. In doing so, the Court of Appeal acknowledged that there may be cases where it is appropriate to look beyond the four corners of the rental agreement to determine the identity of the lessee, especially if the contract is ambiguous in nature. The Court of Appeal applied the principles of agency in finding that Mr. Mahamoud was acting as an authorized representative or agent of Fine Furnishings when he signed the rental agreement. The Court of Appeal was balancing two different approaches to determine who is the lessee. The first approach is to look no farther than the four corners of an unambiguous rental contract in determining the identity of the lessee. The other approach was to apply agency principles to see that sometimes the identity of the lessee is not as simple as the person who signed the contract. Now, moving on to our second case. The next recent Ontario Court of Appeal decision I wanted to discuss also dealt with the judicial interpretation of the priority scheme under Section 277, Sub 1.1 of the Insurance Act. The decision is Enterprise Rent-A-Car and Intact Insurance, and it was decided by a different panel than the first case. The underlying facts are as follows. Miss Addie Peretz was involved in a car accident while driving a rental car owned by Enterprise Rental Car. At the time, she was living with her parents and was a listed driver under the standard Ontario automobile policy issued to her father by Intact Insurance. The policy covered two vehicles she drove regularly, but she was not a named insured on her father's policy. Ms. Peretz was named as a defendant in an action arising from her 2013 accident. There was a priority dispute as to whether Enterprise's insurer or Intact was the first loss insurer. Enterprise and Intact entered into a reservation of rights agreement pursuant to which Enterprise agreed to defend Ms. Peretz in the action until the priority dispute was resolved. In October of 2017, the action settled. Enterprise paid towards that settlement on Ms. Peretz's behalf. Enterprise then sought that amount plus its legal fees from Intact, resuming its claim that Intact was the first loss insurer. The application judge did not agree. The application judge believed that Enterprise's claim on behalf of coverage under OAP issued by Intact was not available to Ms. Peretz for a rental car and that the priority provision in the Insurance Act did not apply. Hence, liability fell to Enterprise's insurer, not to Intact. The Divisional Court upheld the decision on appeal, and the Divisional Court's decision was appealed to the Ontario Court of Appeal, who dismissed the appeal. The Court of Appeal recognized that the purpose of Section 277 is to allocate risk in such a way so as to reduce the financial exposure of car rental companies by making the car rental company's insurance the policy of last resort on the priority ladder that we discussed previously. However, this only works if there is a valid policy of insurance responding to the rungs above. In other words, it only works if there does exist coverage under a policy of insurance on the lessee or the driver. In the case of Ms. Peretz, she did not have her own policy of insurance, and she was not a named insured on her father's auto policy. Section 277, subsection 1.1, does not create insurance coverage where none is available. Where insurance was available to Ms. Peretz depended on Section 2.2.4 of the OAP. And that section provides liability coverage for rental vehicles, but only when the vehicle is rented by the named insured or a spouse that lives with the named insured. In this case, you will recall the named insured was Addie Perrette's father, and since Ms. Perrette is neither the named insured nor the spouse, as a result was not covered by the OAP when driving rental vehicles. Since there was no rental vehicle coverage available to Ms. Perrette's, the priority rules established in Section 277, subsection 1.1 pertaining to lessees and drivers did not have any relevance to this case. Thus, responsibility to provide coverage fell to the owner's insurer, as it was on the bottom rung of the priority ladder. The Ontario Court of Appeal's interpretation of Section 277, subsection 1.1, and the Ontario Automobile Policy is confirmed by the existence of separate optional endorsement coverage providing rental vehicle coverage, which is the OPCF 27. Unfortunately, that was not purchased in this case. However, the OPCF 27 covers listed drivers who drive, rent, or lease other vehicles, and so would have covered Ms. Perrette's. As the application judge concluded, there would be no reason for this endorsement if it accepted, as Enterprise had submitted, listed drivers were already covered. It would render an OPCF 27 redundant coverage. And finally, the third and last case that I am happy to present is a victory of Stieber Burlak's own Carolyn Gronke. It is the decision of Coast Capital Equipment Finance and Old Republic, where the Ontario Court of Appeal held that coverage afforded by endorsements listed in the Certificate of Insurance will apply, even if the endorsement is not attached to the policy. This appeal concerns a dispute between a lessor of a vehicle, Coast Capital, and an insurer as to whether the lessor is insured for third-party liability under a policy of automobile insurance. The appeal turns on the construction of a certificate of automobile insurance and an OPCF 25 change form, both of which was issued by Old Republic. In this case, a trucking company, 622, leased 2 tractor trailers from a third party. The insurer, Old Republic, provided insurance and issued a certificate of insurance in a custom form, approved by the superintendent. The Old Republic Certificate of Insurance referenced an OPCF 5, which extends third-party liability insurance to both the lessor and the lessee. Under the lien holder section, the certificate states, as per OPCF 5 forms, under the section identifying the lessor. 622 leased 2 additional trucks from Coast Capital. Old Republic issued an OPCF 25 change form that, first, described Coast Capital trucks, next, listed Coast Capital as the lessor, and third, stated all other terms and conditions of the policy remain. Although Coast Capital's insurance broker informed Old Republic that it wanted third-party liability coverage, the OPCF 5 was not listed in the OPCF 25 change form. 3 months later, First Insurance, with whom 622 had entered into a finance arrangement, contacted Old Republic to cancel the insurance after 622 failed to make a payment. And unfortunately, as luck would have it, one of Coast Capital's trucks was involved in an accident 4 days later. Old Republic denied liability coverage to Coast Capital on the basis that the OPCF 5 was not attached to the certificate of insurance and therefore did not form part of the policy. The application judge agreed with this reasoning and concluded that there was no coverage for Coast Capital. Coast Capital appealed, and the Court of Appeal disagreed with the decision of the applications judge and held that the OPCF 5 endorsement is part of the certificate and therefore entitled Coast Capital to coverage. The Ontario Court of Appeal explained that a certificate of automobile insurance defines the coverage provided in the policy. Section 232, subsection 5.1 of the Insurance Act states that the certificate of insurance is of the same force and effect as if it were the standard policy, subject to the limits and coverage showed by the insurer on the certificate and any endorsements issued with or subsequently to the certificate. Old Republic's custom certificate of insurance, initially approved by the superintendent, did not contain the phrase "as per OPCF 5 forms," and therefore the phrase was likely added for this particular commercial transaction. The OPCF 25 change form did not delete this coverage, but merely added 2 new vehicles. From this, the court inferred that 2 conclusions were possible. Either first, the certificate issued to 622 intended to provide coverage to both the lessor and the lessee, or secondly, it was Old Republic's usual practice to insure both lessors and lessees for liability. Both conclusions supported coverage for Coast Capital. Old Republic's insertion of the OPCF 5 language into the certificate reflects the commercial reality of the transaction. At the very least, Old Republic should bear the consequences of ambiguity created by its use of an unapproved, altered standard form. Accordingly, the failure to attach the endorsement referred in the certificate of insurance did not render it inapplicable to the policy. We want to acknowledge Carolyn on her excellent and hard-fought result at the Ontario Court of Appeal. And I want to thank you very much for your attention. I'd like to turn the floor over now to my colleague, Sukh Dial, to discuss further recent auto coverage cases at the Ontario Court of Appeal. Thank you. It's my pleasure to be here.
And I want to echo Katie's comments from the outset and thank Michael Connolly for his assistance with both the paper that is in the materials as well as our presentation. I know he's been busy in preparing for his own presentation taking place after us, but I wanted to acknowledge both his significant contribution to both Katie and I. In picking up on Katie's discussion, I'm going to be reviewing 2 Court of Appeal cases from 2019. The first is Kalon and Ace INA Insurance, which dealt with a summary judgment motion dealing with the issue of which insurer, if any, was responsible for providing underinsured coverage to an Ontario truck driver involved in an accident in Florida. And the second case that I'll be reviewing is Pembridge Insurance and Chew, which dealt with a coverage application dealing with the issue of whether Pembridge Insurance owed a defense to its insured Chew under a homeowner's policy for a third-party claim arising for contribution and indemnity from a motor vehicle accident. The background facts of Kalon are as follows. Kalon was involved in a motor vehicle accident in Florida on May 24th, 2011. Kalon had a company which owned a tractor trailer. The tractor trailer in turn was leased to Bell City Transport. Bell City Transport insured the tractor trailer unit under its fleet policy, and then in turn gave the unit back to Kalon to operate as an independent operator. The fleet policy had OPCF 44 family protection coverage. At the same time, Kalon had a personal policy on his personal vehicle with Allstate. It also had OPCF 44 family protection coverage. On May 24th, 2011, Kalon is operating his vehicle, the tractor trailer unit. He comes up to a stoppage. He gets out of his vehicle to see what the cause of the delay is and is struck by a Florida vehicle. While there's not much information with respect to his injuries, there's some suggestion he sustained a traumatic brain injury as a result of the accident, and as a result had significant losses. The Florida vehicle that struck him on the side of the road had insurance coverage capped to $20,000. A summary judgment motion was then advanced to determine which insurer, either the fleet insurer or the personal insurer, was responsible for providing underinsured coverage to him. At the summary judgment level, ACE argued that its policy, through paragraph 22, referenced or designated light commercial vehicles and private passenger vehicles. And as a result, it sought to confine coverage to those types of vehicles. In support of their argument, they referred to an endorsement to the policy, an endorsement 11A, which was entitled Amendment to OPCF 44 Family Protection Coverage. And it argued that this endorsement excluded tractor-trailer units whose gross weight exceeded 4,500 kilograms. And while the motions judge agreed that the private passenger light commercial vehicle designation caused some ambiguity, in reading both the policy and the endorsement together, he ultimately concluded that the endorsement provided clarity to the situation and went on to find that it limited coverage to those types of vehicles only, even though the form of the endorsement itself had not been approved by the Superintendent of Insurance. And as a result of that, the motion judge held that there was no OPCF 44 coverage available to Kalon under the fleet policy. At the same time, Allstate argued a similar exclusion. And while the majority of the motion judge's decision is dealt with or deals with the ACE argument, there's only a few paragraphs that actually reference what Allstate was arguing at the summary judgment level. While it advanced a similar exclusion at the time of the motion itself, the motion judge kind of refers to previous case law, which essentially stands for the proposition that the coverage itself was portable, that it followed Kalon to Florida. And as a result of the fact that there was no exclusionary wording that he could see within the policy, he ultimately determined that there was in fact underinsured coverage available to him under his personal policy. Allstate appealed that decision, and Kalon cross-appealed. Kalon's cross-appealed was denied. The court reviewed the distinction between coverage available to uninsured vehicles, which was mandated by Section 265 of the Insurance Act, and then coverage available to underinsured vehicles, which was dealt with by the optional OPCF 44 endorsement. In dismissing the appeal, the Court of Appeal agreed with the motion judge's reasoning. And it went on to state that even though an insurer is not legally required to provide underinsurance coverage. Furthermore, there's no principled reason why an insurer could not alter optional coverage, as it did here with the fleet policy and the endorsement, even though the endorsement itself had not been approved in the form approved by the Superintendent of Insurance. In regard to Allstate's appeal, Allstate argued that truck drivers like Kalon did not have underinsured coverage available to them through their personal policy for injuries that they sustained as on the job as drivers of their trucks. Allstate argued that this followed a proper reading of both the policy and the endorsement, and in particular referenced sections 2.2.3 of the policy and section 22 of the endorsement. Now, at the outset of the appeal, the court noted that if Allstate's argument was accepted, that it left a large class of people excluded from underinsured coverage, and as a result, it initially adjourned the appeal to allow the parties to deliver further evidence. And in the course of the further evidence that was delivered, the court noted a few things. One, that it could include people like Kalon who were operating an automobile weighing more than 4,500 kilograms, and that insurance to vehicles such as this was highly specialized, and that were only a handful of insurers that provided it. Two, it noted that up until about 15 years ago, coverage for underinsured coverage was available to commercial fleet vehicles under the predecessor to the OPCF 44 endorsement. They no longer provided this coverage because of the increased risk posed by truck drivers traveling to the U.S. in particular. And three, it noticed that while the endorsement claims in the endorsement were rare, they're obviously important to the people making those claims. And none of the experts provided any evidence that the class of persons adversely affected by Allstate's argument would be larger than or include people outside of truck drivers. In considering the appeal by Allstate, the court reviewed the wording of the endorsement. It noted Section 3 of the endorsement, which indicated that the insurers had an obligation to indemnify an inadequately insured motorist. It went on to review the definition of an insured person, which included an occupant of any other automobile. Finally, it highlighted the critical link between the endorsement and the policy, which was Section 22 of the endorsement, which read as follows: except as otherwise provided in this change form, all limits, terms, conditions, provisions, definitions, and exclusions of the policy shall have full force and effect. The court then reviewed the policy. The policy provided certain coverages to Kalon, its personal vehicle, but this did not include underinsured coverage. The policy extended coverages to other vehicles. However, Section 2.2.3 listed several special conditions that imposed limits on the extension of coverages. And the first and most relevant of these special conditions was the first one, which stated that the automobile must not weigh more than 4,500 kilograms. The Court of Appeal then concluded that in reading the policy and endorsement together, the relevant limits, terms, conditions, provisions, and definitions and exclusions of the policy, to which full force and effect must be given under Section 22 of the endorsement form, are the special conditions in Section 2 of the policy, particularly being the first one, that the automobile must not have a weight of more than 4,500 kilograms. And as a result of this, it found that Kalon did not have underinsured coverage available to him through either the fleet policy and Allstate's personal policy. And at the conclusion of the decision, the court noted the difficult circumstance that Kalon found himself in. It went on to state that people in his position were wholly unprotected as a result of the refusal by fleet insurers to offer this type of coverage. And it went on to state that this was, in their words, harsh and unfair, but then also concluded that by saying that the court had no authority to override the contractual language and to provide coverage where none existed in the policy and the endorsement. Instead, that this was something that should be done, or rather was the business of the government to do. So in Kalon, we see the issue of whether a personal policy in Ontario can provide underinsured coverage to a truck driver in Florida, or whether that was something that could be done through the fleet insurance policy. But what we also see in cases is that the expansive circumstances surrounding automobile accidents can give rise to the potential of triggering of multiple insurance policies. And that is something that is evident in the next case that I'm going to discuss, which is Pembridge Insurance. So Pembridge Insurance involved a coverage application that was brought by Pembridge Insurance to address the issue of whether Pembridge owed a duty to defend to its insured CHU as a result of a third-party claim advance for contribution and indemnity arising from a motor vehicle accident. The background circumstances of CHU are as follows. A minor female plaintiff by the name of Tate Moran is involved in a motor vehicle accident in October of 2008. At the time of the accident, she was a passenger in a vehicle, and a vehicle driven by the defendant Fabrizi enters an intersection and strikes her vehicle. Her claim is commenced in March of 2013, and in December of 2013, the defendant Fabrizi delivers a statement of defense. Fast forward a year to December 2014, and Fabrizi's counsel issues a third-party claim. The third-party claim contains the standard motor vehicle negligence allegations that CHU was failing to keep a proper lookout, that he had operated his vehicle at excessive rate of speed, allegations with respect to the mechanical condition of his vehicle. But in addition to all of that, also made allegations of the following: that there was a confrontation of some kind immediately before the accident that had resulted in CHU exiting his vehicle, threatening Fabrizi and a passenger in Fabrizi's vehicle with violence, yelling at them, hitting the window of their car and perhaps other parts of their car, and making other gestures at the scene, which caused Fabrizi and his passenger to fear for their lives. And as a result of this fear, the suggestion is that they got into Fabrizi's vehicle and fled the scene of this altercation, and almost immediately were involved in the motor vehicle accident. Now, excuse me. Now, Chu's father had a home insurance policy with Pembridge. The policy provided that Pembridge would pay sums that the insured became liable to pay as compensatory damages because of bodily injury anywhere in the world. However, the policy contained a number of exclusions, one of them which was that the insured was not covered for claims arising from ownership, use, or operation of any motorized vehicle except those specifically insured. And in this instance, the vehicle that Chu was driving at the time of the accident was not specifically insured. The Pembridge policy also had an exclusion for bodily injury caused by an intentional criminal act. Pembridge took the position that it did not owe a defense or indemnity under the policy given the exclusions. The Dominion was Chu's auto insurer, and the Dominion accepted that it had a duty to defend Chu to the extent that the allegations arose from ownership, use, or operation of a vehicle. However, they reserved their rights for liability not arising from those allegations. The Dominion also argued that its obligations to Chu under the auto policy did not excuse Pembridge from its obligations under the homeowner's policy, and that there was coverage available for both. Coverage available under both policies. The Dominion, the application judge found that the Dominion was required to defend, and that Chu's actions were excluded under the Pembridge policy. The Dominion then appeals and is successful. And the court determines that Pembridge had a duty to defend Chu. The Court of Appeal found that at the time that the threats were made and the assaults attributed to Chu were made, that he was no longer in the car itself and was not using the car. And as a result, this gave rise to an argument that the chain of causation, being the connecting use of the car with the alleged threats and assaults and the subsequent flight and then the subsequent collision, had been broken. And so the court found that there was an argument that the exclusion in the policy, when construed narrowly, did not apply to the assaults. The court also addressed the issue of whether the Pembridge homeowner policy exclusion for intentional acts applied. And the court here examined the pleadings and found that while they set out an intentional act, that they did not contain any allegation that Chu intended to harm Fabrizi. And in construing the exclusion clause narrowly, the court found that since there was a possibility that Pembridge may have a duty to indemnify Chu, there was also a duty to defend.